Hello, this is Evan Conroy with Conroy Law. Today we're going to talk about in Indiana's HOA's ability to assess fines. What are fines? Fines are an enforcement tool available to certain community associations. Essentially, the board imposes a direct monetary consequence against an owner for failing to comply with the community's restrictive covenants. There had been a long-standing question for the Hoosier state as to whether the HOAs could assess fines. This had been a decades-long question. In 1987, there was an Indiana Court of Appeals decision, and in that decision, the court found that language in a community's restrictive covenants, which had provided for a $10 per day penalty for covenant violations, was unenforceable. This created a question of law as to whether fines could be assessed in Indiana. The question of whether an HOA could assess fines was answered this year. There was a House bill that took effect on July 1st, 2026. That bill, through the addition of new language in the HOA Act, expressly authorizes Indiana HOAs to assess fines. You may already know, but for those that don't, Indiana HOAs can be divided into two broad categories. The first type of HOA is subject to all of the HOA Act. The other type is, as you can guess, those that are only subject to some of the HOA Act. Thankfully, the change in law concerning fines applies to both types. However, it's important to point out that the new law was added to the HOA Act and not Indiana's Condominium Act. Because it's only added to Indiana's HOA Act, we have to assume it only applies to HOAs and not condominium associations. The new language concerning fines can be found in IC 32-25.5-3-12. For the rest of the video, I will be providing a brief summary of the new law. I will be paraphrasing some of the language. If you'd like to read the language of the statute in its entirety, I will provide the citation. The first thing to notice is that there is no language saying that you need to have enabling language in the HOA's governing documents. Instead, it can be assumed that, given the way the law is written, all HOAs that are subject to this section of the HOA Act can assess fines regardless if the governing documents don't expressly discuss the authority to impose fines. That being said, the HOA does have to strictly comply with the requirements set out in the new law. First, a board needs to adopt a schedule of fines. What is a schedule of fines? A schedule of fines is an official list that explains the violations that are subject to a set money penalty. For Indiana HOAs, their schedule of fines must include the following. First, the schedule of fines is required to list the type of violations that are subject to a fine. The list of violations can only be violations of the HOA's covenants filed in the county's recorder's office, whether it's contained in a declaration of covenants or within a plat. Violations of the bylaws or articles of incorporation do not count. Additionally, the schedule of fines must list the amount of the fine for each listed violation. The fines that are listed must also explain whether the fine will be assessed one time per violation or on an ongoing or recurring basis. If a recurring violation, the schedule of fines must provide a defined period, number of days, or explain that the fines will stop once the violation has been cured or when some other contingency occurs. There will need to be a description on how the fines are calculated and assessed, along with a max aggregate fines amount for any single violation, with ongoing recurring fines not being able to exceed the max aggregate amount stated in the schedule of fines. After drafting the schedule of fines, the board will need to formally adopt it. When the board seeks to adopt the schedule of fines at a meeting of the board must give notice of the meeting to the members. That notice must comply with the notice requirements contained within the HOA's governing documents. The notice must also include the proposed schedule of fines. Once adopted, the schedule of fines must be available to any member for inspection upon the member's request. As the community begins assessing fines, it may find that the schedule of fines needs to be changed. There are two ways that can happen. The board can amend or repeal an adopted schedule of fines. To do so, the board must give notice of the meeting to be held to amend the schedule of fines. A copy of the proposed amendment to the schedule of fines must also be provided. Like when adopting the schedule of fines, the notice given to the membership must comply with the notice requirements of the HOA's governing documents. Another way in which the schedule of fines can be changed is through actions of the membership. Members can submit to the board a written demand for a special meeting of the HOA's members to vote to amend a schedule of fines. That notice must comply with the HOA Act's requirements for demanding a special meeting. At the meeting, a majority approval of the membership can either adopt a new schedule of fines as proposed or adopt a revised schedule of fines. Now it's time to use the schedule of fines to assess fines. The first thing that needs to occur is the owner must be provided notice of the fine to be assessed. The notice must provide the specific violation for which the fine will be assessed, the amount of the fine, as well as the date on which the fine will be assessed. Additionally, if the fine will be assessed on an ongoing or recurring basis, the notice will also need to provide whether the fines will be for a defined period or a specified number of days, or until the violation is cured, or until that contingency occurs for the fines to stop. There needs to be a description of how the fines will be calculated and assessed as well. Remember, all the particulars must align with the language in the schedule of fines. After being fined, the owner has the right to know the total amount of the fines that have accrued. So if a member is assessed fines, the accrued fine amount must be available to him if he requests it. Finally, it's important to note that assessing fines does not waive the HOA's rights to pursue alternative remedies that are contained in the HOA's governing documents. For example, if the governing documents allow for seeking injunctive relief or pursuing damages, the HOA can still do those things even if it is assessing fines. Thank you for watching this video on how HOAs can assess fines in Indiana. If you would like to learn more about other community association topics, please check out our educational videos. Thank you. Have a great day.